Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's video, we are talking about Amber Heard some more. We are doing part 2 of the things Amber Heard doesn't want you to know about. From her motions in Limine, we are picking up where we left off yesterday. We are on page number... let's see, 42, I think. No, page number 49, at least on the PDF version of this thing. And we are continuing our coverage with the things Amber Heard doesn't want you to know. Dun, dun, dun. Yeah. All right, so let's go ahead and do this. Mr. Marks' testimony does not impact the jury's verdict in Depp's favor on his career and reputation and should be excluded. Mr. Marks' expert designation states he will opine on the positive and significant impact of a jury verdict in Mr. Depp's favor on his career and reputation in the film industry going forward. Mr. Marks is deficient in several respects. First, the expert designation does not even provide his opinion as to whether he believes a jury verdict will have any positive or significant impact on the career and reputation. Mere disclosure of the topic of testimony is insufficient to satisfy the rule. You do have to be a bit more specific than that. That is definitely true. Second, Mr. Marks has failed to state the substance of the facts and opinions with which the expert is expected to testify and a summary of the grounds for his opinion. While Marks testified he intends to testify that a verdict in Depp's favor will have a positive impact on Depp's career, his designations remain deficient under Crane. Third, Marks' testimony as to whether the jury verdict in Depp's favor will have a positive impact on Depp's career is completely irrelevant as to any damages that caused by Ms. Heard and is not probative of any fact in this case. Yeah, maybe. I mean, it goes to his ability to recover. It goes to the ability of the court to be able to provide a remedy, which is something. Whether a future event has any impact on Depp's career and reputation does not imply causation. Whether the damage caused the reputation or the amount of damage allegedly caused. No, it kind of does in some respects, because the degree to which the verdict will be able to solve his problems in some sense goes to show the nature of the problem. Like how much it would help boost his reputation does in some sense it seem to imply, at least in part, the nature of the damages that are there. So yeah, I mean, I don't know about that. Finally, Mr. Marks' conclusionary assertion is not supported by any of his own testimony. Mr. Marks testified he's not aware of any actors accused of domestic abuse who have a jury verdict or judgment at issue other than Depp. Mr. Marks' conclusions are wholly speculative and have no basis in fact. This court should exclude the testimony regarding any favorable jury verdict may have on the reputation and career. Mr. Depp improperly included witness in his witness list for whom he's provided no contact information. In Mr. Depp's list of witnesses for trial, he discloses he may call several witnesses for which he does not provide complete contact information. Specifically, he provides no information or inadequate information for a whole bunch of people. In addition, he failed to identify Leonard Damian and Andy Milner in his responses to Heard's interrogatories, requesting that he identify all persons with knowledge or information about any claim or deficiencies in this case. Mr. Depp's failure to comply deprived Heard of reasonable opportunity to serve subpoenas. All right, and then there's a procedural history, which we'll skip over that. The legal standard, which we'll kind of skip over that. As to Gina Deuters, in Mr. Depp's third supplemental response to witness identification, he directed Heard to contact Deuters through plaintiff counsel. In accordance with these instructions, Heard served subpoenas on Mr. Depp's counsel, seeking production of documents from Deuters and to depose her. Mr. Depp's counsel responded he is not authorized to accept service on behalf and that she was a resident of the United Kingdom, but you asked us to contact you through her. Ms. Heard's counsel then reminded Depp they'd specifically directed Heard to contact Deuters through counsel. Mr. Depp's counsel agreed that this was a means of contact, thereby demonstrating he was in possession of her contact information, yet did not supplement his answer to the identification with an address, email, or telephone number as required by this court's order. About a week before Deuters' scheduled deposition, Heard's counsel asked Depp's counsel to confirm the deposition would go forward. In response, Depp's counsel asserted that because Deuters was resident of the United Kingdom, she was not subject to the subpoena power or jurisdiction of Virginia and would not appear for a deposition. Ms. Heard's counsel again explained the contact information for Deuters in Depp's interrogatory, stating she must be contacted through plaintiff's counsel. Heard counsel further explained that in reliance on this response, they served subpoena on counsel and therefore intended to proceed with the deposition noticed. Mr. Counsel then reiterated various untimely objections to the subpoena. In addition, he offered to see if he was able to obtain certain information, including the address, even though he was required to provide that. On March the 8th of 2022, 3 days before discovery, Mr. Depp's counsel informed Heard's counsel he had been in contact with Deuters for several weeks to see if she'll voluntarily agree to appear for a deposition. Although Depp had had Deuters' contact information for several weeks prior to March 8th, he never supplemented his response to the witness and identification interrogatory with her contact information. Instead, he notified Heard that Deuters was available for deposition the week after discovery closed. With less than 1 week notice regarding Deuters' availability and numerous trial deadlines, Heard had no reasonable opportunity to interview. I mean, that does sound like some problems there. Like, if you're going to say, yeah, contact them through me, you can't then complain, oh, you contacted them through me. Yeah, you can't kind of have it both ways. That's definitely true. And then we get into the specifics as to some other people, which names don't seem familiar, so it seems like these witnesses were excluded, perhaps at least in part based on that. Mr. Depp's witness list improperly double designated certain witnesses to appear by in-person testimony, but reserving the right to call by video link. And in other places have served both deposition designations and include witnesses to testify at trial either by person or by video link. First, Depp has identified Malcolm Conley as testifying by in-person testimony, but reserving the right to call by video link. Similarly, Depp has identified Sam Sakur as reserving the right to call in person, otherwise by video link. Depp's improper double designation of Sam Sakur and Malcolm Conley violate the negotiated audio-visual consent order, which requires that the parties shall disclose specifically on their witness list any witness who will testify remotely via audio means at trial. So yeah, maybe not. You can't like have it both ways. You can't do this because of the consent order. One of the purposes for the language is for both parties as well as the court to plan for testimony and facilitating exhibits that will be needed remotely. A maybe defeats the very purpose of the language in the order. I mean, that's a valid complaint, to be quite honest. That's fair. Like, I need to know because it's going to affect how I'm going to present the case. You can't, like, you can't keep it ambiguous because that's putting a burden on me to prepare both ways, and that's just not fair. That's a reasonable complaint. Second, Depp had also double designated the following witness by reserving the right to call by video link, otherwise by deposition: David Kipper, Isaac Baruch, Christian Carno, Jack Whittington, Adam Waldman, and Kate James. But the court's scheduling order states it's the obligation of the proponent of any deposition of any non-party witness who will not appear at trial to advise opposing counsel of record of the intent to use all or portion of the deposition at the earliest possible opportunity. Therefore, they should not be permitted by testimony to testify via remote video link at trial, only through designation. Again, this just goes to the no unfair surprises. This is a perfectly reasonable objection, at least on the surface, from Elaine and from Heard. It's like you can't have any unfair surprises. You're not allowed that. You can't do trial by ambush anymore in the United States. You have to tell them what you're going to be doing and how, so that they can adequately prepare. Right? And so if we're going to allow trial by in-person and or video link, and it's like, well, tell me which so I can prepare, or tell me that we're going to use depositions so that I can prepare for that adequately. You just got to tell me what you're doing. You can't be like, maybe all the above. That's not really fair to me. I totally understand this argument. This is rational. Dr. Curry's medical exam of Miss Heard should not be referred to as an independent medical exam. Okay, so we're getting into this question as to whether or not Curry's exam is an independent medical examination under the relevant law. On October the 8th of 2021, pursuant to rule, the court ordered Heard to be examined by Depp's designated expert, Shannon Curry, because Heard had been evaluated by Dawn Hughes, Heard's expert. As noted above, Dr. Curry repeatedly referred to his examination as an independent examination. Court ordered independent medical examination and words to the effect. Ms. Heard requests any references at trial to the examination of Heard be called medical examination of Heard, not an independent medical examination, or IME or court ordered. Use of the term independent or court order suggests Dr. Curry is court appointed or otherwise not in connection with the party. Yeah, this is a fair objection because it is possible for a court to designate its own experts. Of course, it's a bit unusual, but not completely unheard of, for a court to have an independent expert. Normally, we just allow the parties to fight it out amongst themselves, but sometimes, and this is usually done in particularly complex matters where the court doesn't have familiarity with the subject matter, so probably not here, because this is kind of routine as far as things goes. But if you have a particularly complex matter and the parties are like wildly divergent, it's not unheard of for the court to order an expert for its own benefit so that they have someone who's kind of trying to be neutral. But then, of course, juries tend to give those kinds of experts a little bit additional weight because they're not affiliated with the party. They're neutral. So they're more likely to give them weight because it's like, well, they're not advocating for either party. They're appointed by the court. And therefore, they're more likely to be an honest broker. So these designations matter. Okay. Dr. Curry's non-independence is clear. Even before she met with Heard, Dr. Curry already concluded that Heard exhibits patterns of behavior that suggest her alleged allegations against Depp are false. Well, to the extent that she's basing that off of medical documentation, that could very well be a preliminary opinion, yes. This is even more important since Dr. Curry's limited experience primarily includes testifying at the request of the court on mental status orders and fitness for duty. The jury can easily be confused and think this is similar in nature and has been requested by the court, and that Dr. Curry is acting on the court's request. Although the court denied the same request on October 8th because of mistaken belief, the rule refers to the examination as independent. The rule does not define a court's ordered evaluation as an independent medical examination or IME. The use of the word independent is nowhere in the rule. Rather, the rule simply labels it as a medical examination. I understand this concern. Right? Dr. Curry is the medical examination is being ordered to occur, but she's not an independent expert. She's being paid for by Depp's team. And we don't want to have confusion on that, which is a perfectly fair objection. Right? We want to make sure that we know that she's being paid for by Depp's team because that might go to her bias, which the jury should be able to factor into the analysis. If the jury thinks that she is being paid for or being ordered by the court, that might leave a very different impression in the jury's mind. So it's a perfectly reasonable objection, to be quite honest. And then they go on to note that these are done, that these are typical. Yeah. The jury should be instructed to ignore any redactions in medical and mental health records and not give redactions any significance or speculate. This is a perfectly reasonable objection. If we're bringing in medical records, portions of the medical records may be redacted. If they're redacted, they are not valid evidence. So the jury should give them no weight and not consider what they could be. Right? The jury is probably going to be really curious, but as far as instructions go, yeah, you're not to consider this. Of course, the jury is going to consider it anyway, but, we're going to assume the jury is not going to do that because, legal assumptions. So on August the 10th, 2020, this court ordered Hipaa Release pertaining to protected information from medical professionals for her that was limited to Miss Heard's medical and psychological treatment. Yeah, so people ask all the time, what about Hipaa? Okay, what about Hipaa? Right? Hipaa is a federal law that applies to patient privacy records, but the law defines the nature of the privacy. And one of the things the law provides for is court-ordered releases. So it's like it's protected by Hipaa. Well, the court says, no, not so much. Okay, well, that's what the law allows for. The order was further affirmed again when the court held that the scope will be limited, as we stated previously. So it has to be limited in scope. Depp then again moved to expand the scope of the Hipaa release. We'd like more records, please, which the court has denied. In consideration, certain medical records were redacted based on Hipaa. The court held that Hipaa releases are the same for everyone. And if the attorneys took that and did what they did to redact it, I go with those redactions. So yes, if the attorney's redactions are the same as my redactions, then, same difference. That's fine. Ms. Heard requests that based on the court's previous 3 orders, Mr. Depp be presented from raising at trial, questioning or suggesting there's anything important or relevant in the redacted materials. This is perfectly normal practice, right? If the records are coming in, but they've been redacted because of whatever, then those redactions are not evidence. So the jury should not consider the redactions because they're not evidence. Don't worry about what's behind the curtain. It's of no value. That's legally correct. Sure. Yeah, that makes sense. Mr. Depp has included partial audio recordings produced as Depp whatever in these exhibits. These are also 2 partial audio recordings linked to the Daily Mail by Mr. Depp's counsel Waldman. This also explains why the metadata identifies the audio content that was created in 2015, but somehow modified in 2016. Therefore, they should be excluded as incomplete documents on the grounds of hearsay, no, and because their probative value as only partial recordings is substantially outweighed by danger prejudice. Yeah, this motion would wound up being denied because the audio recordings were made by Heard. So Heard would have the originals because they were made by him. So there is no problem if they have been edited because you have the originals. And if you don't, that's a you problem. And no, they are not unduly prejudicial. They just make your client look like a horrible, horrible person. But, you know, that's not prejudice. That's just reality. So, yeah, no, not so much with that. Counsel for both parties should be precluded from referencing the court's rulings or parties' respective allegations against each other during the pleadings, motions, or discovery. Fair. More specifically, the parties should be precluded from referencing or characterizing the following discovery-based allegations. Yeah, to the extent that these matters have already been hashed out, they've already been hashed out. So we should be excluded from doing the things that we've already hashed out. I mean, yeah, right? So references to this court's rulings, yeah, references to discovery sanctions brought or released, right? It's like you just present the evidence, right? If there's been sanctions, you just present the evidence. You don't make a point of saying this has been ordered by court sanction because that's unduly prejudicial. That's perfectly reasonable. All these matters are not evidence that could be admitted. They're not. The court's rulings are not evidence. And their probative value is none, which is true because they're not evidence, because they're court rulings. They're not evidence. So that makes total sense. Evidence regarding Paul Barese and any investigation should be excluded. Consistent with references to counsel in earlier discovery, proceedings, and the likes, Depp's counsel has raised in depositions the allegation that Miss Heard hired an adult film star as a private investigator in this case. Okay, that's interesting. Miss Heard, apparently there's some suggestion Miss Heard hired an adult film star as a private investigator. Okay. This person is not testifying, has nothing to do with discovery in the case. Moreover, whether a private investigator hired by earlier counsel was previously an adult film star, even if true, which has never been demonstrated, is likely not relevant. I suppose whether or not they're an adult film star may not necessarily be relevant to whether or not they're a good private investigator, but those do seem like very, very different professions. Any references to a pretend punch should be excluded. Mr. Depp should be precluded from introducing testimony of an alleged pretend punch of Miss Heard by unknown person that nobody personally saw except by an alleged video that does not exist. Such testimony is wholly irrelevant, inadmissible hearsay within hearsay, likely confuse the jury, and unfairly prejudicial. Mr. Depp seeks to offer testimony of a video that does not exist. Mr. Depp counsel admitted in the UK the video does not exist, cannot be authenticated. Well, if it doesn't exist, then yeah, that would make authentication really, really hard. How can you authenticate the non-existent thing? That's a new trick. Likely to confuse the jury, and unreliable and unfairly prejudicial. Mr. Depp inappropriately seeks to introduce testimony of a video that does not exist, is not probative, and would be unfairly prejudicial. The alleged video, supposedly from surveillance cameras at the Eastern Columbia building that some employees have attempted to interject into their testimony, has never been produced in discovery because it does not exist. Mr. Depp's counsel in the United Kingdom case admitted the Depp team does not have the video. Similarly, the corporate designee for Action Property Management, the custodian of records, testifies as the following. So to the extent that footage has not been produced, is it fair to say the footage no longer exists, or do you have another explanation? Can you expand on that, please? My understanding is you testified there were 87 clips that have been preserved. Is that right? Yes. And the date and timestamps are reasonably accurate to your knowledge on those? Yes, as to my knowledge. And to the extent there's any missing date or time, is it fair to say the footage no longer exists? Or is there any other footage that could have been produced? Outside the videos that were requested, that's correct. No, everything else would have been written over at this point. So there's no other videos other than those that have been produced. To your knowledge? Yes, correct. And this footage was never found. Is that correct to your knowledge? The footage was never requested. By whom? Any of the attorneys. So the footage, is it your testimony that exists, the footage exists or not? It no longer exists. And it would no longer exist, and it was never produced as one of the 87 clips. Is that right? That is correct. I believe you testified earlier that the attorneys for both sides selected times and looked through the videos and made selections of what to preserve. Is that your testimony? Yes, that's correct. But no one selected that footage. To your knowledge? Not to my knowledge, no. And it was never produced? Not to my knowledge, no. There's no dispute the alleged pretend punch video does not exist, has never been authenticated, and a jury would never be able to see it. That is a problem. A jury, therefore, could never render its own finding as to what happened in the alleged video. Yeah, testimony about what people saw in a video that is not available presents all kinds of problems that they themselves didn't see in the first place, right? If they themselves had this is like, if they themselves had seen it in the first place and also seen the video, then they could testify about it, because like the video, assuming the video existed at all. So we're going to go on the premise the video existed at some point, right? Then they would be in a position to say, yes, I saw it personally. And yes, I also saw a video. Here is the video I saw, right? And I personally can authenticate it because I was there, right? I can authenticate the video I saw is true and accurate, even though the video no longer exists. It's been overridden. It's been lost, right? So this principle deals with how do you deal with evidence that's been lost or destroyed, potentially through no fault of anyone, because evidence isn't always available. How do you do that, right? So this is also, incidentally, like in contracts, right? There has to have been a writing with the writing right to satisfy statute of frauds in certain kinds of contracts, right? Blah, blah, blah. So what if the writing no longer exists? No problem. Can anyone testify the writing did exist? Right? So you could have a witness come on the stand, like in a contract case, and be like, yes, this contract, it was reduced to writing, or there was a writing that evidences the contract, right? Where is the writing? Well, but there was a writing. Yes. How do you know? I was there. I was there, my friends, and I saw the writing. I saw it, and it was signed by the parties in my presence, right? And I read the document. I read the document myself, and I saw the parties themselves sign the document. Where's the document now? But it existed. Yes, it did. I saw it. So as long as you have personal knowledge of the thing, you know you're well on your way to it being there. Like the fact that the writing is no longer available, well, it was reduced to writing, so, you know, okay. So now we're going to have oral testimony about a written document that no longer exists, but it did exist, so that's fine. You can do that. So if they had observed the fight themselves or whatever, they observed this fake punch, then great. If all they observed is the video itself, then that's a bit of a problem, because how's the video being authenticated? And if the video no longer exists, then yeah, we're running into all kinds of problems. So yeah, these objections seem pertinent, right? It's like, I saw the video. Okay, the video itself is now evidence, and you're testifying to its authenticity, which you didn't see the underlying incident. So how do you know it's authentic? And yeah, it raises all kinds of problems. So you know, this makes sense. This totally makes sense. All right. Let's see. Carrying on. The plaintiff should not be allowed to introduce testimony respecting a non-existent pretend punch video because it involves a non-party and not probative. Even if the alleged video existed, which it does not, testimony about such would be wholly irrelevant. A pretend punch by an unknown person has no tendency to make any material fact more or less probative. Well, if it's not of Amber Heard pretending to punch or of Johnny Depp pretending to punch, then it does seem a little bit off point. And it's also inadmissible hearsay within hearsay. Yeah. There's definitely problems there. Yeah. Plaintiffs should not be allowed to introduce evidence of the non-existent pretend punch because any probative value is substantially outweighed. When we don't have the original, and no one, and it doesn't involve the parties, and no one is available to testify about it themselves, because, like, you know, why testify about the video if you can just testify about the incident? But except, of course, in my written contracts example, right? Why testify about the document when you can just testify about what the party saw? Well, because of, as I mentioned, certain kinds of contract require it to be evidenced by writing. So the fact that there's a document is itself an important factor in the analysis, right? It's like, oh, we have a contract over land. We have a contract for goods of more than $500 and so forth and so on, right? We have a prenuptial agreement. It's a contract in contemplation of marriage. Where is the prenuptial agreement? I don't know, but it existed. Right. So the fact that the document existed is now a material fact that is relevant to the trial. The fact that this video existing is like, eh. So I feel that. Rick Gee in chat says, if a punch lands in the forest, but there's not a video, you got it. And Regina Health becomes a member. Well, thank you very much, Regina, for your fine. Becoming a member and joining the Uncivilians. Your name, too, will soon appear on screen with all the other cool Uncivilians, because that's one of the member benefits by hitting that beautiful, beautiful join button. Upon our next stream, your name will be available because you have hit the beautiful join button. And other people should hit the join button, too. Okay. Use of the declarations, UK witness statements, or prior testimony should be excluded unless properly used as impeachment. Yeah. I mean, yeah, what was said in other trials is not itself admissible in this trial, right? Yeah, right. Those statements in other trials, those statements themselves should not be used in this trial, right? Let them testify now about it, or not, before this jury. These parties, and incidentally, there are different parties. So first, it's different parties. If it were the same parties, we'd be having a different discussion. Second, even though it's the same parties, we would still be having a different discussion because the thing we're bringing in is in a completely foreign court, in a different country, right? If it was the same parties, and they had an opportunity to cross-examine in a different case, we would be asking different questions. But these are different parties. And even if they were the same parties, it's involving a trial that occurred in the UK, not under US law. So that raises a whole host of problems on issues. So yeah, let's not bring in that stuff. That's perfectly reasonable. The testimony and prior statements of Jennifer Howell should be excluded in their entirety. Plaintiffs lift Jennifer Howell as a person with knowledge of claims and defenses in this case in response, but after deposing Ms. Howell, it became clear she has and had no direct knowledge of any claims or defenses in this case, and her testimony is completely based on hearsay and hearsay within hearsay, and is irrelevant and more prejudicial than probative. Plaintiff has designated portions of Howell's testimony where she described Whitney, Miss Heard's sister, speaking on the phone in another room with an unknown person, and Miss Heard, Whitney, telling her the person had said Amber cut off Plaintiff's finger. These allegations based on hearsay are also described in the testimony. This game of telephone, cute, also contains hearsay within hearsay under the rule, and there are no exceptions to either statement. I mean, there are problems because we've got issues like, yeah, Whitney said that Amber said that, blah, blah, blah. But it is a statement that Amber said, so now we just have to get past the fact that Whitney said it. So, but there's definitely some hearsay rabbit holes we can run down on that for sure as well. All correspondence regarding any Warner Brothers stipulation or declaration, their contents should be excluded. Correspondence between counsel respecting Miss Heard's Aquaman damages among counsel should be excluded as a compromise offered during negotiations. Ooh. The relevant rule provides that any communications made during settlement are not admissible, is basically what the rule says. These communications are also inadmissible as they're irrelevant. Mr. Depp subpoenaed Warner Brothers Entertainment for personal appearance and business records. In response, Warner Brothers filed a motion to quash in the Superior Court of California. See, that's what you do. That's how you deal with a subpoena you don't want or is overbroad. That's the right way to deal with it, right? You don't want to respond to that subpoena? That subpoena is overbroad? That subpoena is improper? What do? Motion to quash. What don't you do? Just fail to supply records. This is how you do it. Motion to quash. There you go. Mr. Depp then filed opposition to motion to quash and a motion for sanctions. In an attempt to avoid motions practice about subpoena and avoid being disposed, the counsel for Warner Brothers sent a letter requesting it meet and confer, and proposed draft a sworn declaration setting the following. Any delay in Warner Brothers picking up the option for Aquaman 2 was due to creative issues in casting Heard in the role of Mira, which were communicated to Heard's agent at the time. Any delay in Warner Brothers picking up Heard's option for Aquaman 2 was not due to Heard's dispute with Depp or any other allegation in the lawsuit, and Warner Brothers would not have paid Heard any more money on Aquaman 2, even if Heard had had more time to negotiate. We're not going to give her any more money because she's not worth any more than we're paying her. Not sure she's worth what we are paying her, but that's a whole nother separate questions. Yeah. Legal Vices says, I wish I had named my channel name without prejudice. Hey, as long as it's not taken, Legal Vice, it's not necessarily too late, man. I changed my channel name. This channel used to be called Internet Law Review way back when. And Nate the Lawyer, as we commented, changed his name. I think he's gone through 2 different names at this point. So as long as without prejudice isn't taken, Legal Vice, change that channel name. Change it now. If you think it's the superior channel name, man, go nuts. It's up to you, man. Glad to have you here, by the way. As always, glad to have Legal Vice's participation. All right. Counsel for Miss Heard was willing to negotiate with Warner Brother, and counsel for Depp sent a proposed stipulation concerning the matter of Miss Heard's Aquaman 2 damages, potentially foregoing her damages if Depp was willing to agree not to raise the matter at trial. Counsel for Depp then provided a declaration to the Superior Court suggesting the stipulation was take it or leave it, when in fact it was an initial draft sent in word in an effort to resolve the dispute. Ultimately, the parties did not agree to a stipulation or declaration regarding the Aquaman 2 damages. Counsel's communication regarding the stipulation and declaration were made during compromise negotiations and should be excluded. Okay. Let's see. What else do we got? Christian Carno's first day of deposition should be excluded. Eric George's answer based on attorney-client privilege. If it's properly excluded, it shouldn't be referenced by the parties. That's fine. Should be precluded from references and characterizations of the counsel or prior motions and court rulings. Yeah, you don't do that, right? You don't do that. You don't bring in court rulings. Like, you just use the court rulings. You don't say the court ruled this. Like, that's the prejudicial to the jury, right? If the court made a ruling, you're bound by the ruling. You don't then go in and say, well, the court made a note of this. The court sanctions. That's unfairly prejudicial, right? Unless the court says you can. But if otherwise, you don't do that because it's unfairly prejudicial. You just use the material as the result of the sanction and you move forward with your life. Yeah. People are now giving advice to Legal Vices on the name of his channel or not, and I'm here for it. It is awesome. Okay. So, yeah, I don't know whether or not Legal Vice should change his name or not, but it is an option that's available as he debates the merits of whether his name is the best name or he needs a new name, and so forth and so on. When I first adopted the name Uncivil Law, I said, yeah, we'll give it a try and see how it works out. I don't know whether or not we have stopped giving it a try or not. Now that we've hit 100,000, maybe we've stopped giving it a try. I'm not quite sure how that works. All right, carrying on. Should be prohibited from referencing and characterizing Miss Heard's counsel or prior motions. That's fine. All references to legal process utilized by her to obtain the California TRO should be excluded. Counsel for Depp has repeatedly referred to Miss Heard obtaining an ex parte TRO in the divorce case, suggesting or implying it should not have been ex parte, or this was somehow a deviation from valid California process. However, Depp has not identified any expert witness to testify on correct procedure for obtaining a TRO, nor whether obtaining a TRO was standard, a deviation, or some other process would have been preferable or appropriate. All references to the suggestion they obtained an ex parte TRO was inappropriate. I mean, all right, fair enough, I guess. Throughout litigation, Mr. Depp has attempted to link his damages to conduct by Ms. Heard outside the op-ed, even though the sole basis for the defamation is the op-ed. Mr. Depp's expert disclosure also attributes damages to alternative causes associated with Ms. Heard. Mr. Depp's claims for defamation and litigation all stem from one publication, the op-ed. Ms. Heard anticipates Mr. Depp will attempt to confuse the jury into believing they can hold her responsible for damages conduct outside the op-ed, including back in time in the divorce. Mr. Depp should be precluded from claiming or arguing any open statement, questioning of witnesses, closing argument, or at any other point from that anything other than the op-ed is sufficient for returning liability. I mean, we definitely saw that in the court's instructions that, you're limited to the op-ed because that's what's at issue. So, yeah, that's perfectly appropriate. Suggestions that she has an army of attorneys, yeah, that's inappropriate. Okay, we should be excluded from offering payment about legal fees. The identity of the payer of attorney's fees is not relevant to any issue in this case. It does not tend to make any material fact more or less likely. Evidence of Amber Heard's insurance coverage and insurance payment of attorney's fees therefore should be excluded. In addition to being wholly irrelevant, evidence of who's paying each side's legal fees should be excluded because the probative value is substantially outweighed by damage to unfair prejudice. Here, the evidence of who's paying attorney's fees for each side is unfairly prejudicial and very likely to confuse the jury. For these reasons, they move to exclude. Okay, then we want to exclude all the settlement negotiations. And then we reach a conclusion. Okay, so that was the 71 pages of motion, but we're not done yet, my friends. We are not done. Because there's pages of attachments, which we are now going to skim. All right. So not to fret, my friend. We still have like 920 pages of attachments. I'm not even exaggerating. So we have a transcript of proceedings and the magistrate court. And this is apparently some of the proceedings that occurred in the UK. Oh, this is the decision of the UK, at least in part. This is the UK's decision. So this is the UK judgment. So we could read that, but, no, let's exclude that. Okay, so Commonwealth, discharge of offenders without proceedings prior to conviction. So this is Australia, I think, laying out the crimes that are potentially at issue and whether or not they were discharged or not appropriately under Australian law. The transcript of Whitney. We could go through Whitney's transcript in assorted detail in terms of things. Whoa. Who decided black on white? Wow, that's really hard to read. Okay, that's annoying. But we could go through Whitney's testimony in detail, I suppose. Here is, let's see, what is this? A videotape deposition of Depp. So going through that, I suppose. Transcript of a hearing conducted virtually before the Honorable Penny Ascarte. Let's see, from this hearing. This is a partial transcript. The court, all right, thank you. Mr. Chu, Your Honor, if I could have just a few more minutes for rebuttal. The court has been very indulgent with this trial. I'll be the court, great. Court, Chu, quick. Let's raise some issues I'd like to address very quickly. Okay, all right, yes, sir. Thank you, Your Honor. First, with respect to chart, we apologize if we filled out the chart incorrectly. This is our first experience with it. We weren't trying to be ponderous. We're trying to respond to the court's request. Second, with respect to the conciliator, is ironic. We oppose the conciliator, not because we don't want to conciliate, but because we know that Miss Bredoff would try to relitigate every single discovery issue that's been resolved by Chief Judge White. And Chief Judge White said that, I know what Mr. Chu is saying is true. You will, Elaine, try to relitigate everything that's happened, and that's why I'm not appointing a conciliator. But to get to substantive matters, Miss Heard did not say that she had pledged the money to the ACLU and the Children's Hospital, Kids with Cancer. She said she did it. Her testimony was, the entire amount of my divorce settlement was donated to charity. This wasn't an offhand comment in a deposition. This was a sworn statement she filed. She didn't say she pledged it. She's now saying after the fact, oh, gee, no, I really haven't given any money to those charities other than the $100,000 that Mr. White gave at the time of the divorce. It was, I really couldn't give the money because Mean Johnny sued me. Good times. Well, her lawyer admitted that it was Miss Heard, in fact, who initiated the first action against Depp. It was an arbitration matter that was dismissed by Judge whoever. So she was the one who actually filed the first shot and had no intention of giving the money to charity. Fourth, with respect to the additional communications relating to the Children's Hospital and ACLU, they are clearly responsive. They've not been ruled on. And Elon Musk is in fact the anonymous donor. It's relevant for several reasons. One, Elon Musk is on film as having seen Miss Heard in the days after May the 21st, 2016. That is the date where all four police, came to the condominium and all testified there was not a sign of damage on Miss Heard's face and there was no disturbance to the apartment. I'll get to that in a moment. But this point is Mr. Musk saw her in the week between the alleged abuse and the time she got the ex-party TRO on May 27th of that week. So he's clearly, oh damn, well that's the end of that deposition. That was the end of that testimony. But that was fun for a minute. Yeah, I think Ben Chu might be a bit of a snarky guy. But I appreciate that because I'm a bit of a snarky guy too. Ben Chu and I can definitely roll together. He's definitely someone I appreciate. Ascarati. Thank you, Brianna, for the pronunciation correction. Ascarati. All right, so we have income statements, blah, 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 financials, boring financials, blah, 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 blah. Do we have anything interesting? Let's see. Ordinary income. Whose profit and loss? I guess there's some interesting stuff in here. Let's see. Income from operations. So these are Johnny Depp financials. Let's see. Profit participation from Chocolate Fa, $1.1 million. Profit participation from Hell, $94,000. Profit participation Rum Diaries, $672,000. Residency for Once Upon a Time in Mexico, $2,000. Those are residuals. I apologize. Residuals, Once Upon a Time in Mexico, $2,000. Residuals, Charlie and the Chocolate Factory, $21,000. Residuals, Corpse Bride, $4,000. Residuals, Sweeney Todd, $111,000 in the year to date. So that's for the 12 months ending 2009, in case you care about such things. In 2010, income from operations, The Tourist, $14 million. Residuals, Once Upon a Time in Mexico, $1,600. Residuals, Charlie and the Chocolate Factory, $17,000. Residual, The Corpse Bride, $468. The Corpse Bride isn't paying out very much. Residual, Sweeney Todd, $24,000. Profit participation, Charlie and the Chocolate Factory, $1 million. Sweeney Todd, $148,000. From Hell, $109,000. Reimbursed expenses, The Tourist Productions, $126,000. That's a lot of reimbursed expenses, man. Let's see, 2011. Fees, Disney Fees, Disney and Lebkowitz Porta, $200,000. Fees, Warner Brother UK Dark Shadows, $20 million. Residuals, Once Upon a Time in Mexico, $1,300. Charlie and the Chocolate Factory, $11,000. The Corpse Bride, $5,000. Sweeney Todd, $26,000. Imagination of Dr. Parmusu, $1,700. Royalties from Sweeney Todd Music, $6,500. Profit participation, Charlie and the Chocolate Factory, $1 million. From Hell, $73,000. Reimbursed expenses from the Taurus Productions, $38,000. Income from investments for per diem and housing from the Dark Shadows, $1.3 million. That is a lot of per diem and housing expenses. I'm just saying. Total income in 2011, apparently, from at least these expenses, $22.6 million. Okay. L&D financial statements. Residuals, this is 2012. Residuals, Once Upon a Time in Mexico, $1,700. Charlie and the Chocolate Factory, $9,000. Corpse Bride, $2,000. Sweeney Todd, $13,000. Imaginum of Dr. Pernusis, $200. Not great residuals on the Imaginarium of Dr. Pernusis, $200. Residuals from I Love You Man, $1.71. Wow. $2, man. $2. $2 residuals from I Love You Man. Not going great. Oh, it gets worse, though. Residuals from Rum Diary, $8,000. And residuals from Dark Shadows in 2012. The residuals from Dark Shadows in 2012. Drum roll, please. 3 cents. 3 cents. Okay. Wow. All right. Profit participation, Charlie and Chocolate Factory, $700,000. Profit participation from Hell, $6,200. Reimbursed expenses for the Sure Glock What production, $300,000. Total income from operations is $1.1 million, including the 3 cents from the residuals of Dark Shadows. Dark Shadows is not paying the big bucks on the residuals. That is hilarious. All right. 2013 income. Fee, Into the Woods, $1 million. Fee, Montreal, $11.4 million. Fee, UK tax, $124,000. Fee, UK tax, $56,000. Residuals, Once Upon a Time in Mexico, $2,000. Charlie and the Chocolate Factory, $12,000. Sweeney Todd, $5,000. Imaginarium of Dr. Pernuso, $250. Rum Diary, $9,700. Dark Shadows, $64,000. Royalties, Sweeney Todd, Music, $2,500. Profit participation, Charlie and Chocolate Factory, $600,000. From Hell, $72,000. Income from investments per diem Into the Woods, $5,000. Total income was $13.3 million in 2013. This is exciting stuff. All right, 2014. The Johnny Depp financials continue. Income from operations. Fee from Montreal in the UK, $760. Fee from London Fields, $4,000. Fee from Alice H, $12 million. Alice is paying it out. Residuals, Once Upon a Time in Mexico, $800. Charlie and the Chocolate Factory, $5,100. Sweeney Todd, $2,100. Imagination of Dr. Pernuso, $80. Once again, the imagination is not paying out that great. Rum Diary, $818. Dark Shadows, looks like $8,100. Royalties from Sweeney Todd Music, $1,700. Profit participation, Charlie and the Chocolate Factory, $758,000. From Hell, $35,000. Reimbursed expenses. Shadow Dark Productions, $100,000. Reimbursement for expenses of Montreal, $307,000. London Fields expenses, $700. Total income, $13,240,000 in 2014. Is I don't know. I'm doing the best I can in reading the print. 2015. Fees, Pirate 5, $24,986,410. Pirates 5 is doing well. $25 million in fees. Residuals, Once Upon a Time in Mexico, $1,200. Charlie and the Chocolate Factory, $10,200. Sweeney Todd, $5,700. Imaginarium of Dr. Pernusses, $96. The Rum Diary, $2,500. Dark Shadows, $1,700. Residuals for music and Sweeney Todd, $1,400. Profit participation, Charlie and the Chocolate Factory, $717,000. From Hell, $62,000. Profit for par sale of content partner, $1.9 million. Reimbursed expenses for Pirates 5, $350,000. Into the Woods, $96,000. Total income, $28,173,000. So Pirates 5 is driving a lot of that in 2015. 2016, income, Alice, $300. Fantastic Beast 2, $2 million. From Hell, $59,000. Pirates of the Caribbean 5, $10,000. Per Diem, Into the Woods, $1,000. Residuals, Charlie and the Chocolate Factory, $11,000. Dark Shadows, $10,000. Imaginarium of Dr. Pernuso, $62. Once Upon a Time in Mexico, $700. Rum Diaries, $273. And Sweeney Todd, $5,400. Gross profit of $2 million in 2016. 2018, Fantastic Beast 2, $500,000. Profit participation from Dark Shadows, $394,000. From Hell, $75,000. Reimbursed expenses from Boswell, $245,000. Expenses, Murder on the Orient, $166,000. Residuals, Charlie and the Chocolate Factory, $11,000. Dark Shadows, what is that? $6,000, I think that is. Fantastic Beasts and Where to Find Them, $23,000. Imagination of Dr. Pernuso, $25. Well, $24 because it rounds down. Murder on the Orient Express, $19,000. Once Upon a Time in Mexico, $960. Pirates 5, $11,000. Rum Diary, $78. Sweeney Todd, $4,000. Also, Waiting for the Barbarians, $500,000. Total profit, $2.4 million in 2018. 2019. I am confused by the way this is being split up. I don't even understand how this is being done in the accounting. This confuses me. Why are there two different January to December time periods? I'm going to skip this because I don't understand this accounting sheet. 2020. Boswell, Fantastic Beasts, $6.2 million. From Hell, $31,000. Murder on the Orient Express, is that $518,000, I think that is. Into the Woods, Residuals, Charlie and the Chocolate Factory, $4,000. Dark Shadow, $1,200. Fantastic the Crimes, $23,000. Fantastic Beasts and Where to Find Them, $8,000. Imagination of Dr. Pernuso, $87. Murder on the Orient Express, $3,300. Once Upon a Time in Mexico, $640. Pirates 5, $3,500. Richard Says Goodbye, $10,000. Rum Diaries, $45. Sweeney Todd, $2,100. Total profit, $7.4 million in January to August of 2020. And then we have 12 months entering 2009, and then we've got year-to-date for a whole bunch of residuals. This is 2009. Yeah, so L is L-com is 2019, mid is 2018, R was plus minus 2018-19. Yeah, I'm still not clear on that, so but I appreciate you trying to help. So in 2009, our income was as follows. Jigsaw production for Gonzo, $7.5 million. No, apologies. That's Cheap as Dirt was $7.5 million. Jigsaw production for Gonzo was $760. Pirates 4, $15 million. Residuals, Late Show with David Letterman, $940. I didn't know you got residuals from being on Late Show with David Letterman, but apparently you do. Edward Scissorhands, $2,400. Fear and Loathing, $7,000. Crybaby, $750. Benny and June, $1,200. Blow, great movie by the way, $1,700. Nick of Time, $800. Gilbert Grape, $178. Pirates of the Caribbean, I'm assuming the original, $14,000. Dead Man, $7,000. Secret Widow, $3,000. Donnie Brasco, $4,300. Ed Wood, $1,100. King of the Hill, $87. Chocolat, $835. Arizona Dream, $16. Gonzo, $12,000. Royalties, BMI, $873. Sleepy Hollow, $55,000. Fear and Loathing and profit participation, $100,000. Reimbursement expenses, NBC Universal, $4,200. From Disney Worldwide, $72,000. From Brandsnatch Properties, $132,000. From Cheap as Dirt, $73,000. From Rum Diary Productions, $32,000. Total income from operations in 2009, $23 million. From 2010, Pirates 4, $18 million. The Tourist, $6 million. Alice in Wonderland, $1.5 million. When You're Strange voiceover, $75,000. Residuals from David Letterman, $900. Edward Scissorhands, $4,000. Fear and Loathing, $3,000. Crybaby, $2,000. Benny and June, $2,000. Blow, $2,500. Nick of Time, $1,700. Gilbert Grape, $1,000. Pirates of the Caribbean, I'm assuming the original, $18,000. Dead Man, $4,000. Secret Widow, $13,300. From Donnie Brasco, $13,000. Apologize, $1,300. Ed Wood, $560. King of the Hill, $150. Gonzo, $1,500. I Love You Man, $1,300. Freddy's Dead Fight Night, $7,000. Don Juan Descardo, $2,000. No, that's more like $1,000 rounded. Public Enemies, $16,000. The Astronaut's Wife, $800. Alice in Wonderland, $250. Royalties from BMI, $2,000. Profit participation, Sleepy Hollow, $41,000. Fear and Loathing, $40,000. Donnie Brasco, $250,000. Pirates of the Caribbean 1, $625,000. Ninth Gate, great movie. It's probably my favorite Johnny Depp movie, to be honest. Still getting paid all these years later, $93,000. Respect, Alice, $17.2 million. Profit participation from Public Enemies, Public participation from Public Enemies, $4.2 million. Ed Wood, $8,200. Pirates 2 and 3 are apparently clumped together for some reason, $3.2 million. Reimburse expenses for production of Alice, $8,500. Rum Diary, $1,500. Total income in, what was this, 2010? Yes, $51.4 million we made in 2010. It was a good year for us in 2010. 2011 income. Pirates of the Caribbean 4, $12,000. Clips from uses of Pirates 4, $9,000. Commercial tie-ins to Pirates 4, $650. I mean, I'm not an expert on such things, but that kind of seems low. I don't know. But whatever. Foreign commercial clips, $2,000. Life voiceover, $25,000. 21 Jump Street, the movie, $10,000. Jack and Jill, not a great movie, $10,000. Residuals, Late Show with David Letterman, $1,600. Edward Scissorhands, $2,800. Fear and Loathing, $3,700. Crybaby, $800. Benny and June, $1,700. Blow, great movie, $1,200. Nick of Time, $608. Gilbert Grape, $605. Pirates of the Caribbean, $4,000. Dead Man, $25. Secret Widow, $2,500. Donnie Brasco, $700. Arizona Dream, $220. Gonzo, $209. I Love You Man, $330. Freddy's Dead Final Night, $67. Don Juan Darcano, $190. Public Enemies, $14,000. The Astronaut's Wife, $380. Alice in Wonderland, $104,000. A Nightmare on Elm Street, for some reason, we're getting residuals for in this year, $3,100. Residuals, Pirates of the Caribbean, $4,500. Buried Secret of M. Night S, which I'm assuming that's M. Night Shyamalan, $1.50. The residuals on the Buried Secret of M. Night Shyamalan, $1.51. King of the Hill, $98. The Tourist, $21,000. Rango, $292. Pirates 2, $4,100. Total residuals, $173,000 in those years. Okay. And then let's see, this is 2011. We're not done yet. Royalties, BMI, $900. Profit participation, Sleepy Hollow, $64,000. Pirates of the Caribbean 1, $600,000. Ninth Gate, $28,000. Alice, $28.2 million. Public Enemies, $2.4 million. Ed Wood, $7,800. Pirates 2 and 3, which we're grouping together for some reason, $9.8 million. Blow, $420,000. Reimbursement expenses, Disney Worldwide, $890,000. Rango, $126,000. 21 Jump Street, $27,000. Pirates 4, $354,000. And then we got some refunds for total income in, what is this, 2011, total income, $43 million. So, you know, I guess the $1.50 we got from the Buried Secret of M. Night Shyamalan really helped us in our $43 million payday. Okay, 2012. Fees, When You're Strange, voiceover, $15,000. Clips from Pirates 4, $9,000. Nike athletic apparel appearance of apparently some kind, $100,000. Family Guy, $900. Okay. The Lone Ranger, $21 million. For that movie, he was a bit overpaid, I think. But okay, he got paid $21 million. Okay. Talk shows, $1,000. The theme park, Pirates Legend, $150,000. He's getting paid apparently for his likeness at the theme park, but only getting paid $150,000. Residuals, Late Show with David Letterman. We're still getting residuals from this thing. $500. Edward Scissorhands, $2,000. Fear and Loathing, $1,200. Crybaby, $1,000. Benny and June, $1,100. Nick of Time, $1,200. Gilbert Grape, $1,000. Pirates of the Caribbean, $9,000. Dead Man, $460. Secret Widow, $5,400. Donnie Brasco, $1,800. Gonzo, $1,900. I Love You Man, $320. I guess it proves that money can't buy you love. Friday Dead Final Night, $1,400. Don Juan DeMarco, $7,000. Alice in Wonderland, $27,000. A Nightmare on Elm Street, $1,400. Pirates 3, $4,100. Please take note, for some reason, we're not combining Pirates 2 and 3 at this point. I don't know why. King of the Hill, $48,000. The Tourist, $80,000. Rango, $380. Miscellaneous SAG, we got $385 from SAG somehow. I'm not quite sure about that. Pirates 2, $11,000. Pirates 4, $6,000. Jack and Jill, $2,000. 21 Jump Street, $1,300. Profit participation, royalties, BMI, $300. Profit participation from Sleepy Hollow, $80,000. Fear and Loathing, $100,000. Pirates 1, $1.4 million. Ninth Gate, great movie, $29,000. Alice, $6 million. Public Enemies, $1.9 million. Ed Wood, $9,000. Pirates 2 and 3, which again we're combining now, $2.8 million. Blow, oh wow, my voice just cracked. Blow, $26,000. P4 merch, Pirates 4 merch, I suppose, $300,000. And then profit participation from P4 itself, $2.7 million, $12.7 million even. Reimbursement expenses from Pirates, $73,000. Reimbursement expenses from Lone Ranger, $983,000. Miscellaneous income from Disney, $675,000. Per diem on the Lone Ranger, $53,000. Total income in 2012, $48.5 million. For 2013. Yeah. He gets some merch money, but not much, apparently. His fees for Pirates 4, $650. The Lone Ranger, negative $3.6 million. So, yeah, I'm not quite exactly sure what happened there. I guess they recalculated the amount paid. So his income from the Lone Ranger, in 2013 was negative $3.6 million. I'm sorry. It's just wow. Okay. The Lone Ranger really is not paying off for anybody, apparently. Wow. Talk shows, $2,500. The fee from Transcendence, $20 million, and fees from a commercial tie-in for the Lone Ranger, $20,000. Well, that will offset the $3.6 million we owe you back. Good times. Okay. Residuals. Late Show with David Letterman, which continues to pay off for some reason. $1,100. Edward Scissorhands, $2,200. Fear and Loathing, $2,500. Crybaby, $700. Benny and June, $1,000. Nick of Time, $1,400. Gilbert Grape, $500. Pirates of the Caribbean, $2,600. Dead Man, $568. Secret Widow, $6,800. Donnie Brasco, $2,000. Arizona Dream, $13. I Love You Man. No, wait. Gonzo, $381. I Love You Man, $120. Friday Dead Final Night, $330. Don Juan DeMarco, $2,400. Public Enemies, $3,400. Alice in Wonderland, $26,000. A Nightmare on Elm Street, $2,600. Pirates 3, $2,200. King of the Hill, $145. The Tourist, $30,000. Rango, $26,000. Family Guy, $1,900. Miscellaneous SAG, $74. Residuals on Pirates 2, $3,300. Pirates 4, $5,400. Jack and Jill, which somehow is not negative, $5,800. 21 Jump Street, $9,600. The Libertine, $19,000. And Ellen, $428. From Jimmy Kimmel, we got $385. From BMI, we got $1,400. On the Sound Exchange, we got $2,000. Profit Participation, Sleepy Hollow, $50,000. Ninth Gate, $20,000. Alice, $6.2 million. Public Enemies, $2 million. Well, no, apologize, I shouldn't have rounded that high. Public Enemies, $1.2 million. There you go. Ed Wood, $12,000. Pirates 2 and 3, $2.4 million. Blow, $128,000. P4, Pirates 4, $2.0 million. The Tourist, $677,000. Reimbursing expenses from Disney, $587,000. From Transcendence, $500,000. Total income in that year was $30 million. Some of which, we had to pay. It would have been higher. But we had to apparently give back $3.6 million in fees for the Lone Ranger. But it's okay. It's okay. On the year, we still cleared out $30 million. So I guess it's not all bad. Although, that's still 10% of your income. So, I mean, that's got to hurt a little bit, but still. All right. In 2014, clips for use of Pirates 4, $1,200. Talk shows, $1,500. Fees from Montresia or whatever it's called, $3.4 million. Commercial tie-ins for the Lone Ranger, $2,400. You're getting overpaid, man. You're getting overpaid. Black Mass, $15 million. Fee from Tusk, $3,000. From Christian Dior, $3 million. Okay. So in 2014, I guess, is when our Dior contract is starting. And we're getting $3 million from Christian Dior, which, as we all know, that Sauvage is now the #1 cologne in the world. So, it's worked out really well for Christian Dior. And apparently worked out okay for him starting in 2014. $3 million from the fragrance. I bet it's going to go up as we get into further years. Drew becomes a member. Thank you for being a member. Thank you for hitting that beautiful join button. Residuals from David Letterman, which continue to pay. $300. Edward Scissorhands, $2,000. Fear and Loathing, $2,500. Crybaby, $678. Benny and June, $3,200. Blow, $3,000. Nick of Time, $700. Gilbert Grape, $600. Pirates of the Caribbean, $4,000. Dead Man, $900. Secret Widow, $3,500. Donnie Brasco, $1,500. Arizona Dream, $500. Gonzo, $600. I Love You Man, $111. Freddie Knight, Final Night, $101. John Juan DeMarco, $415. Public Enemies, $2,400. The Astronaut's Wife, $700. Alice in Wonderland, $22,000. A Nightmare on Elm Street, $1,700. King of the Hill, $140. The Tourist, $17,000. Rango, $14,500. Family Guy, $757. Pirates 2, Dead Man's Chest, $3,200. Pirates 4, $6,800. Jack and Jill, $1,300. And 21 Jump Street, $1,300. From Drew, 10 pounds. Hi, Kurt. Nice to catch live again. Hope you're doing great. Glad to be a member. Keep up the amazing work. Well, I am feeling pretty good, by the way. Thank you very much, Drew. This channel is growing. We're at 104,000. That's nice. We got 500 people watching this live. That's also very nice. And people seem to be responding positively to most of my videos, which is nice. Also, I have adopted a new thumbnail style in the hope of achieving something that maybe represents a uniform brand. Will it work? Will it not work? Who knows? But, it's an idea. And, we have the thumbnail of this video. So the thumbnails going forward, at least for the immediate future, should look more like this, which should help to recognize a more uniform branding. And branding is good. So all those good things are working out. So yeah, life is pretty good. Also, you know, I don't have the stress of my old job, which was depressing me very, very literally. Also, I don't have the stress of the bar exam, which is a whole thing. So that was a lot. Also, I've been to the gym the last 2 of the last 3 days. So that was nice, trying to get my exercise on. Way overdue, but we'll try. Things are going okay in the Uncivil Law world at the moment. We've got our silver play button peeking out from behind here. We got our license to practice before the United States Supreme Court. Life's not too bad, man. Life's not too bad. Yeah, so I hope you like the thumbnails because you're going to be seeing more of them. So, yeah, and we're going to try to rotate the colors of the thumbnails. Now, I realize I kind of broke that rule today because I did 2 orange in a row, which was not intentional. But we'll try harder in the future to rotate the colors so that there will be more difference between them. So, yeah. I guess I could go in and change the colors each time, but we'll see. Anyways, doesn't matter. Life is going okay. Great. Let's press on. Where were we trying to read all this stuff? I think we finished all those residuals. Jimmy Kimmel, $500. Lone Ranger, $9,400. Royalties from BMI, $850. From the Sound Exchange, $600. Profit participation, Sleepy Hollow, $92,000. Fear and Loathing, $58,000. Pirates 1, $380,000. Ninth Gate, $17,000. Alice, $3.3 million. Public Enemies, $400,000. Ed Wood, $13,000. Pirates 2 and 3, $4.8 million. Blow, $200,000. Pirates 4, $9.5 million. The Tourist, $850,000. Reimbursement expenses from Rum Diary Productions, $350,000. Transcendence, $170,000. Moricarty, $49,000. Black Mass, $400,000. So in 2014, we made $42 million. 2015. From talk shows, $1,700. From a Paul McCartney session, $400. We're getting paid to play with Paul McCartney? I mean, I'm just saying, man. It's Paul McCartney, and we're getting paid to play with him? That's pretty awesome, man. Okay. Fair and Balanced gave $10 to say, Kurt, that's amazing to hear about the gym and getting healthy. I'm trying to, while it's a biatch, it's starting to become routine. So proud of you. Congrats on the play button. Keep up the work. Well, thank you, Fair and Balanced. It's very, very kind of you. I appreciate it. Residuals from The Late Show with David Letterman. How long can we get residuals from David Letterman? Damn. $104. Edward Scissorhands, $2,700. Fear and Loathing, $1,900. Crybaby, $1,000. Benny and June, $2,000. Blow, $1,700. Nick of Time, $700. Gilbert Grape, $500. Pirates of the Caribbean, $4,800. The Dead Man, $600. Secret Widow, $3,300. Donnie Brasco, $1,700. Gonzo, $500. I Love You Man, $140. Friday Dead Final Night, $170. Don Juan DeMarco. I can't believe I just did that. Okay. $600. Public Enemies. Wow. Public Enemies, $1,600. The Astronaut's Wife, $2,400. Alice in Wonderland, $14,000. A Nightmare on Elm Street, $1,500. Pirates 3 at World's End, $1,800. King of the Hill, $100. The Tourist, $7,000. Ringo, $11,000. Those who know. Family Guy, $490. Family Guy, $2,000. Pirates 2, $2,000. Pirates 4, $3,000. Jack and Jill, $1,600. 21 Jump Street, $3,200. Ellen, $368. Secret Widow? Secret Window? Okay, well, it's secret something. It's one of the secrets. It's fine. Let's see. Ellen, $400. Jimmy Kimmel, $10. Jimmy Kimmel's not paying that great. Lone Ranger, $5,000. Transcendence, $27,000. Tusk, $1,200. Montreal. Drew gives me 10 pounds. Laughing my ass off. Thank you very much. Montreal gives $5,300. From Into the Woods, $2,400. Royalties from BMI, $900. Sound Exchange, $1,200. Profit participation, Sleepy Hollow, $62,000. Pirates 1, $650,000. Ninth Gate, $23,000. Alice, $2.2 million. Public Enemies, $653,000. Ed Wood, $10,000. Pirates 2 and 3, $2.5 million. Blow, $77,000. Pirates 4, $5 million. The Tourist, $500,000. And profit for sale of content partners, $3.8 million. Reimbursed expenses, $230,000. Black Mass, $170. Total income in 2015, $15.6 million. It's good stuff, yeah. Now, I'm not going to continue reading through all this, but I'm interested to see if Dior gets mentioned some more, because I'm interested in his income specifically from Dior. So I'm going to skip ahead for future years and see if Dior pops up again, because I think otherwise we kind of got the drill. In 2018, we made $16 million. In 2019, from Dior, we got paid $7 million in 2019 from Dior. Did we get paid anything in 2018 from Dior? Let's see. Yes, $4.2 million in 2018. In 2017, did we get paid anything from Dior? $4 million. So 2016 from Dior, we got paid $3 million. 2017 from Dior, we got $4 million. 2018 from Dior, we got $4.2 million. 2019 from Dior, we got $6.9 million. 2020 from Dior, $2.5 million. And that's the end of that in terms of the residual. So we don't know how well he's doing in subsequent years. But given that he's the number one, given they're the number one brand, I'm sure he's doing quite well on his Christian Dior contracts right now. What was the $10 million legal settlement? I don't know. It's just listed as a loss. I mean, let's see, was there a settlement listed? Oh, other income. He's getting income from TMG. So I don't know who TMG is, but apparently there was some lawsuit involving Johnny Depp and TMG, and he's getting paid $10 million in settlement. So I'm not sure exactly what that's about, but hey, there's a story there. If you guys want to try to figure out what's going on with the TMG thing. Who is TMG? Why are they cheating him? Why is he getting paid $10 million in legal settlements? I don't know, but he's getting paid. Do we have residuals on Amber Heard? I don't know. Maybe we do. That'd be hilarious. I don't know. But these are all the financials for Johnny Depp. Then we got a transcript of a hearing, or at least part of it. Okay. Mr. Nowdoff. And so I'm going to start off with our motion to compel Mr. Depp's charitable donations. And in particular, it's a request for production 9 of the 12th request for production, where Heard requested documents sufficient to reflect Depp's charitable donations of either money or time from 2010 to the present. Really? We want him to prove he donated? Okay. I mean, we can just, there's pictures, but okay. To be clear, we're not asking for all documents. We're just asking for documents sufficient to reflect his charitable donations. So I don't think it's a burdensome request. The court, no, I don't think it's burdensome. Relevance is the question. Mr. Nanoff, right. So there were a few couple issues. One, Mr. Depp, as you know, as I've heard, has made a big deal out of Miss Heard's donations to and pledges to ACLU and the Children's Hospital. And I'm sure Mr. Chu is going to come up here and say she's depriving children, sick children, of money and time, but that's not true. It's a little true. And it's not even part of the complaint, but he's gotten discovery on that. Yeah. What we're seeing is what we don't want them to make, the argument, and then say, Mr. Depp, and he's talked about his donations to the LA Children's Hospital and the ACLU. And I can pass it up, but I mean, Depp has made it public that he's made contributions. Yes, to which there are photographs and videos and proof of him actually giving a damn. The court, right, but I want to make, you're saying because they're getting it, we should get it? No, I'm not, it's not we're doing tit for tat, it's definitely you're doing tit for tat. It's also that his reputation is also at issue. No. So what we see is if we see he's increased his donations after certain events, like he's had a drug or alcohol issue, and his donations going up, he's trying to improve his reputation, we should be able to get some information that's sufficient to see what donations he's made, where he's made it, and be able to see if he was doing this to improve his reputation. He's put his reputation at issue, and so part of improving your reputation is donations to the public. The other issue we've really found here is that shows this relevant is we went to them and say, okay, let's just do the LA donations to the Children's Hospital, donations to ACO, and Depp will agree that he will not testify as to his charitable donations at trial. They wouldn't agree to that. They wouldn't agree that Depp won't testify. That is that they don't want to give trial strategy. Well, if he's going to testify as to his donations, he's admitted its relevance. I assume you object to relevance if he starts. Well, testifying donation, sure. But now it's in front of, now it'd be in front of the jury. We're also going to have to make a motion limine. If we can have an order now that say Mr. Depp will not be able to testify as to his, or will agree not to testify as charitable donations, we can, along with the ACLU and Children's Hospital donations, we could live with that. I bet you could. That way it ties a loop around any donations made to the ACLU or Children's Hospital. And then we've not left to wonder whether he'll testify, about trial donations down the road, and we don't need a motion to compel. They say they said in their papers they're not identifying to have him testify. Let's have an order that says he can. And if you're not going to do this, if you're not going to order that, he should produce the documents. Then order at least saying he will not testify as to the donations. That would be sufficient. All right, I understand. I don't know if you could do a clear order saying he won't testify because a lot of things could happen in trial. You never know. It's fluid. But I mean, it could be, well, we could approach, obviously, the bench before you get into the issue. I mean, we could. Well, how are we? Do something like that. How are we going to know if he's going to do something like that? And if he goes into that and somehow he is, does that get to him to testify? Now we have no documents at all to be able to challenge him on. I mean, we can't have it both ways. He can't make it may be relevant. It may be able to testify to it, but not relevant for discovery purposes. I mean, there's a point to be there. Okay. And again, we're just seeking documents sufficient to show his donations, at least the ACLU and Children's Hospital, if not all of it. And show again, if he's increasing his donations after he has an incident, a public incident that goes to his reputation. And we can see why he was. And then we can see as to making those donations, who he was making it to. And again, he's also taking credit for, the ACLU or at least Children's Hospital donations. So it's at least a relatively limited request. It's either we can't get the discovery, then Mr. Depp should be ordered that he cannot, or if he cannot be something he can testify to trial, which is somehow we agreed to, but it won't then commit to it in a consent order. I mean, yeah, you can't kind of have it both ways. I mean, that's fair. Mr. Chu, good afternoon, Your Honor. May it please the court. Ben Chu for Johnny Depp. This is a motion to compel. It's not a motion to eliminate. And we respectfully submit the court should deny it as a motion to compel, as this category of documents, because they're irrelevant and not reasonably calculated to lead to the admissible evidence. Unlike Ms. Heard, Mr. Depp has not put his charitable donations at issue. Ms. Heard did that by saying, quote, I played no role. Strike that. Ms. Heard did that by saying, quote, money played no role for me personally. It never has, except to the extent I could donate to charity, unquote. What a joke. She hoodwinked the judge in England, who apparently believed her sworn statement, her first sworn statement, that she donated all $7 million of her divorce settlement to Mr. Depp. And the judge cited that as a basis for concluding that Ms. Heard was not a gold digger. We had to pull teeth to prove it was false. Ms. Heard objected to our subpoena to the Children's Hospital. When she lost that and was sanctioned by the judge in LA, she took it to the Court of Appeals. Imagine taking a discovery issue to the Court of Appeals, which rejected it in record time. And as soon as records show, Ms. Heard in fact gave zero to Children's Hospital of Los Angeles, except for the $100,000 that Mr. Depp gave in the wrongful impression that Ms. Heard was serious when she pledged the $3.5 million to the Children's Hospital of Los Angeles. I like Ben Chu. I like his snark. I can get behind this snark. This is good stuff. So when Ms. Heard's counsel keeps telling you it isn't true, they know it's false. In fact, we had an emergency hearing before Chief Judge White to deal with Bredoff marking those documents produced by Children's Hospital of Los Angeles. The Children's Hospital of Los Angeles did not mark them as confidential, but Bredoff did so retroactively. How fun. We had an emergency motion. Chief Judge White found in chambers there's no basis to be marked as confidential. Ms. Bredoff stated, but there's no emergency here. And Chief Judge White said the emergency is your bad faith. Good times. So that was the bad faith. So they keep saying it was not true. They know it's true. Mr. Depp has not made his charitable donations an issue. If they want to do that, they can do that. Thank you, Your Honor. The court. All right. Thank you. All right. Anything further? Mr. Naldoff, really quickly, Your Honor, respectfully, Ms. Heard did not make this an issue. It's not. And one, not part of Johnny Depp's complaint. It was never mentioned in her. It was never mentioned in her op-ed. She never mentioned charities or charitable donations. She never mentioned that at all, anything in terms of complaint. Well, she did mention being a she did mention basically being a spokesperson for the ACLU in her op-ed. 2 years ago, I became, okay. In terms of a discovery order to the appellate court, Mr. Depp has done that in our request to try to get documents from Depp's counsel. He's taken it to D.C. Court of Appeals. They tried to have a stay, and it was denied quickly. All of Mr. Chu's arguments were about Ms. Heard's pledges and donations. We're simply seeking at minimum whatever Depp donated to the ACLU and LA Children's Hospital. And if that, at a minimum, we'd be seeking that. I said before why we believe it's relevant. His donations and how it could go to reputation. I do think it's relevant. Yeah. And again, if Depp is going to testify to that, which he's still not saying he won't, then it would need to be relevant for the purposes of discovery. He's right, it's not a motion in limine, but why not? I mean, why not have us go through all that? If he won't commit to that, he can't have it both ways. He can't say it's relevant. It may be relevant, but not relevant for discovery. So unless you have other questions, the court. No, it's fine. Thank you, Your Honor. The court. As to charitable donations, the court just does not find relevance in this matter to compel. So I'm going to deny the motion as to that. All right, I believe the next issue is documents related to defenses and denials. And then they move on to other stuff. That's hilarious. That's good shit, man. I mean, it's like the emergency is your bad faith. I mean, that's good shit. That's good shit. All right. The motion to compel. Let's see if we got anything here. The motion is believed to be moot as to contracts related documents. Okay. They're willing to produce responsive documents, so the request is moot. So this is a request for production? Yeah, this is a request for production. So your request is moot because we've already provided it. The objections related to defenses are appropriate. Okay. Is not entitled to privileged documents? The objections documents related to denials are appropriate? Mr. Depp's charitable donations are irrelevant. Ms. Heard's request for productions regarding requests for information and interrogatory responses are improper. This is just like classic. This is just a discovery fight. This is par normal. Courts really don't like discovery fights, but it's not unusual. Usually in discovery fights, no one wins. Usually the court hates everybody. Although it can obviously depend on the circumstances. But, they really want everyone to sort of, okay, and here's a transcript of Waldman. And then they go through like the stuff that they're objecting to. We don't need to go through that in detail. But, there's transcripts of Waldman, if you're into that kind of thing. This is all, of course, in the documents provided by Andrea Burkhart. This is document number 29 in the series, if you want to look it up. The defendant's motion in support of the motions in limine. So it's number 29 in the series of document, and Andrea Burkhart has all these documents on her website. And thank you all for all of you who contributed to helping get them released so that we can all share them together. Okay. Blah, 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 blah. Let's see if there's anything in here that's good. Stephanie, this is from David Murphy. All right. Email from David Murphy to Ben Chu et al. Okay. Regarding supplemental disclosure of Mr. Neumeister. Stephanie, your email is disappointing for a number of reasons and does not even answer the one critical inquiry. First, as you know, Mr. Depp has already unsuccessfully tried to argue that Ms. Heard failed to timely comply with a relevant order. As fully briefed and argued by Heard, it was Mr. Depp's counsel who repeatedly ignored Ms. Heard's communication, which Mr. Depp's counsel continues to do on this very email chain, to get her devices imaged per the court order. Following Mr. Depp's expert ignoring communications and attempting to schedule with the imaging, while complaining how busy he was and only available during very limited times on specific dates, which were accommodated, Mr. Depp's expert then demanded the use of specific hardware by Mr. Young, but simultaneously refused to provide the hardware for the use. The court then agreed by denying the motion on this exact issue, which I've argued. Perhaps that is why your email refers to when Depp received photographs, because you know, and the court agreed, none of this can be blamed on Ms. Heard. Second of all, this is the first I'm hearing of technical glitches, but this is due to choices made by Mr. Depp. At the same March 4th hearing, based on Mr. Depp's demand, the court changed the data exchange process to Craig Young himself, making 2 copies of the review data onto 2 USBs and then sending them to each party's expert. Previously, Heard's expert received the data and then within 24 hours sent an exact duplicate to Depp's expert, and the process was seamless. So once again, this delay was due to choices and demand made by Depp, and your implication was this was an error tied to Heard is again a misplaced projection. I can't say that this isn't normal in civil cases. Civil cases can get a little so it's third, it's a little unprofessional, but unfortunately not unusual. Third, you indisputably represented that Neumeister would identify a date certain to produce supplemental expert report by March the 18th and then failed to do so. Trial begins less than 3 weeks. Mr. Depp's position that he hopes to have a date certain is not workable at this late stage. Following Mr. Neumeister's production, Ms. Ackhart will need time to prepare his opposition. Mr. Ackhart, will need time to prepare his opposition report, and we need time to review both before deposing an expert. We're running out of time. Therefore, please either confirm or deny by 5 p.m. today that Mr. Neumeister will produce a full and complete supplemental expert disclosure by 5 p.m. on Thursday, and Mr. Neumeister will appear for deposition by Zoom at 10 a.m. Eastern, either on the 5th or 6th, for up to 7 hours. And then there's an email chain. David, as you know, we are still receiving a large volume of photographs, all of which were substantially delayed as a result of Ms. Heard's failure to timely comply with the relevant order. The first tranche of photos not being received until March 2nd, several months late and on the eve of trial. Mr. Neumeister is now receiving many thousands of photographs, 58,000 and counting, many of which are outside the scope's order, and yet not in position to provide a report. Setting aside delays, there also be seen some technical glitches. This past Saturday, Mr. Neumeister received a drive that had 0 images on it. Moreover, several iTunes backups have still not even been processed. We hope to have a date certain by which supplemental report will be provided. We're amenable to continuing Mr. Ackhart by mutual agreement beyond the expert cutoff, and therefore will plan not to proceed on Wednesday. However, we reject any suggestion you're entitled to require that Mr. Neumeister be deposed before Mr. Ackhart. Wow. Stephanie, I'm following up on these matters once again. With Mr. Ackhart's pending deposition and trial quickly approaching, Mr. Depp ignoring these issues and refusing to respond is inappropriate and highly prejudicial to Ms. Heard, especially when Mr. Depp committed to identifying by March the 18th the date on which Mr. Neumeister will produce supplemental expert disclosures. Please identify Depp's positions on these matters. It's civil litigation, man. Civil litigation can get ugly. I don't know, man. Stephanie, as the below emails reflect, Mr. Depp continues to identify a date certain for production of full and complete supplemental expert disclosure by Mr. Neumeister by yesterday, but received no further response. Please respond to this by providing the agreed information. Stephanie, thank you for your response. This email confirms parties' agreements. The tomorrow notice deposition of Mr. Neumeister is being continued and will serve an amended notice once we have a new date for his deposition. Following the date, he will serve the supplemental expert disclosure. We also think it makes sense to continue the deposition of Mr. Ackhart for the same reasons, but defer to Mr. Depp. Paul says, thank you for your time. To review seems like more work than you did for the bar exam. I don't know, man. The bar exam was just cramming so much information in my head. It's like just like cramming like all the subject matter. It's just so much information. Fortunately, I don't have to retain this information. So I've got that going for me. I'm not going to be quizzed on it later. Ben et al. We're writing regarding the status of Brian Neumeister producing a supplemental expert disclosure. Please identify dates certain on which Depp will agree to provide supplemental and complete expert disclosure. As you know, Ms. Hurd is entitled to a full and complete disclosure of Mr. Neumeister's opinions of both advance of both deposition and trial. Good times. From a court transcript conducted on November the 20th, 2020, and we enter in media res. Second category of documents relating to other litigation which Mr. Depp has been involved, as Your Honor has seen. These requests are hopelessly broad and overburdensome. Even with Ms. Bredoff's reported limitations, she still seeks all witness interactions, Mr. Depp's explanations, Mr. Depp's perceptions, any all photographs, etc. Having been involved in all those cases, Your Honor, I can say that none of those cases has anything to do with Ms. Hurd or alleged abuse by Ms. Hurd or any other woman, because the only other woman in Mr. Depp's 57 years who's ever accused him of abuse was Ms. Hurd. The Bloom case involved Mr. Depp's former lawyer, who illegally took 5% of his income from a period of 1999 and April 2017. Judge Green in Los Angeles declared the alleged oral contract was violative of the California Business and Professional Code. As a result of the ruling in the case, the firm Bloom Hergart was disbanded because he had perpetrated the scheme of several other people, including Sylvester Stallone. That case involved also 1 million documents. I believe it. Mr. Depp and Ms. Hurd were only married for 15 months during the 18-year period. The TMG case involved Depp's former manager prior to Ed White. Mr. Mandel was the manager from 1999 through March 2016. He breached fiduciary duties and appropriated tens of millions of dollars. Again, the case involved approximately 1 million documents, most of which were designated confidential by defendant, which is the same. This is true as well in the Bloom case. The Rocky Brooks case is a comically frivolous case involving an incident more than a year after divorce. The Bodyguards case involves an esoteric dispute as to whether the two gentlemen employees or their employees or independent contractors. I mean, that can matter quite a lot, actually. So none of this had anything to do with Ms. Hurd or the alleged claims of abuse. The court should deny the motion as to whatever. That's all we have. So, yeah, those are some of the documents. Well, my friends, I think that is enough for now. We've been an hour 43 into this, and I think we will conclude here. And if you guys like this, and you guys respond well to this, we might have more, depending on your interest. There's so many. We're on page 244 of 995. So we still have 700 pages to go. So many pages to go. So many pages of material. But, my friends, we can't be all Johnny Depp all the time. Mitova says, did you get your results? Yeah, not for 2.5 months. I won't get results for the bar until mid-October because the essays have to be graded by hand. So that takes time. So it's going to be a while till I get results. And I'm not feeling the most confident I've ever felt in my life. I felt more confident after taking the first bar exam 15 years ago than I do now. I'll tell you that. So, we'll see, man. I will take note that there have been criticisms of the bar exam from Above the Law and others. And I wound up not really liking my Above the Law video because I did a video about the Above the Law thing and I just wound up not liking it. So I wound up, removing because it just didn't like it. I mean, sometimes you do something, you're like, I don't know, it's just not really working. It isn't what I really wanted it to be. It's not working. It's like, So I wound up taking it down because I thought it was, yeah. True Blue became a member. Thank you very much, as always. It's appreciated. So, yeah. So, I hope all that makes sense. Happy with whatever you think is interesting as a professional lawyer. I appreciate that. Sometimes you just are not sure about things, and you're just you're not sure what's good or what's bad, and you're just trying to make it work. Oh man. Yeah, you're sure I did fine? Yeah, the criticisms on Twitter about the bar exam, the criticisms of people, I think a lot of people felt very beat up by that bar exam. So we'll see. I'm not super duper confident. We'll see. But yes, SD Trekkie Girl says you watch whatever videos I put up. That's very nice of you. I appreciate that. All right, I'm going to sign off for now. If you have not done all the YouTube things already, why not? You should do all the YouTube things. You should like, comment, subscribe. Is the subscribe button red? Are you looking at the subscribe button right now? The subscribe button, if it's red, is mad. Grrr. But you can soothe it. Merely by clicking the red subscribe button, it will become a gray, calm, integrated, at peace with itself subscribe button. And it will be of benefit to the world. So click the red subscribe button. You can be the change we all want to see today. Make sure to like the video and hit the beautiful join button. I have been Uncivil Law. Until later, my friends, I hope all is well. Cheers and goodbye.